Welcome to Theme 2, Rights and Responsibilities of the AQA GCSE Citizenship course. We're looking at rights and responsibilities within the legal system. In particular, how does the court system work in the UK? In the last two videos of Session 6, you would have looked at the difference between statute and common law and looked at why it is important to have both of them. You would have found out what we mean by the term judiciary and the separation of powers. You would have also looked at the roles and qualities of a judge, and you would have looked at how to become a judge, comparing the process of recruitment in the USA and the UK with an opportunity to practice a 4-mark question. In this video, you're going to be looking at the difference between Crown Courts, Magistrates Courts, and Tribunals. This diagram here shows the court system in England and Wales. Please make sure you familiarise yourself with this. It's very important that you know it. The diagram also shows you what types of judges sit in which types of courts. So who presides over each court or tribunal. The key things you need to know is that there are criminal courts, civil courts, and employment tribunals. Over here you have 2 civil courts, and people are entitled to appeal the decisions made in these courts, and it will be taken up to the High Court. Again, people have the right to appeal the decision here, and it will be taken up to the Court of Appeal. The opportunity to appeal does exist here, and it goes up to the UK Supreme Court, and if it's a human rights issue, the case can be taken further to the European Court of Human Rights. So these are cases such as the Abu Qatada case or the Hurst case, which we looked at in another video about human rights. If the case goes to the UK Supreme Court and it involves an EU-related issue, it can go to the European Court of Justice. Once leaving the EU, the European Court of Justice will no longer apply to the UK. Ultimately, the UK Supreme Court is the highest court in the UK, unless the case has to do with human rights issues, and then the case can be taken to the European Court of Human Rights, which was established by the European Convention of Human Rights. Another thing to note in terms of civil courts is that you've got family courts and county courts. Family courts would deal with family issues. County courts would deal with other civil cases. In terms of criminal courts, you've got magistrates courts, where all criminal cases go to in the first instance, and they decide whether it's serious enough to go to the Crown Court, or if it can be trialled there. So this is where less serious crimes might be heard. The Crown Court, on the other hand, is where more serious crimes are heard. An arrow is over here because magistrates can refer cases to the Crown Court if it's too serious for magistrates to preside over. Defendants in the Magistrates Court can appeal decisions at the High Court. They can then further appeal the decision to the Court of Appeal and ultimately the UK Supreme Court. Again, if the case is a human rights issue, they could appeal it further. If it's an EU-related issue, they could also refer it further, but to a different court. If you want to appeal a decision made in a Crown Court, it goes straight to the Court of Appeal and not to the High Court. Again, decisions can be appealed here, and the same rules apply in regards to the European Court of Human Rights and the European Court of Justice. Over here, you can see employment tribunals. It starts off at a first-tier tribunal, then an upper tribunal, then an employment tribunal for England, Wales and Scotland, then the employment appeal tribunal. Again, it feeds into the appeal process. Just be aware that there are a number of other tribunals outside of this structure, for example, school exclusion panels. Their supporting legislation explains their individual appeal routes. What we're going to be looking at now is the Crown Court and the Magistrates Court. We're now going to look at the 2 criminal courts, the Magistrates and the Crown Court, and we're going to compare the differences and similarities between the 2. This here is the Crown Court, and this is the layout of the Crown Court. The first thing you need to know about the Crown Court is that more serious crimes go to the Crown Court. In fact, all crimes initially go to the Magistrates Court, and the magistrates decide if it's too serious to remain at the Magistrates Court or whether it needs to be referred up to the Crown Court. In the Crown Court, you'll find a judge. Judges deal with major offences. There is only one judge who sits in a Crown Court. It is their job to hear the evidence presented in court and decide on a sentence. They are legally trained and have a lot of legal experience. They are also paid. In the Crown Court, you'll also find a defendant. The defendant is the person accused of committing the crime. They may or may not testify at the trial. The reason why they're called a defendant is because they are defended in court. One of the principles of the UK legal system is a term called the presumption of innocence. It's very important that you understand what this term means. The presumption of innocence refers to a defendant being assumed innocent until proven guilty. What that means is that the prosecution must prove the defendant's guilt using evidence. It's not the job of the defence team to prove the defendant's innocence, but the job of the prosecution and the prosecuting team to prove the defendant's guilt. In a Crown Court, you'd also find a jury. A jury is made up of 12 jurors. They are randomly selected and are members of the public. They must decide on the verdict. This is if the defendant is guilty or not guilty. They must stay impartial, meaning neutral, and only make their decision based on evidence from the case. There is a head juror who speaks on behalf of the jury. You can serve on a jury once you are 18, so long as you are on the electoral register, and fulfill other criteria that you look at another video in the Rights and Responsibilities folder. In the Crown Court, you'll also find defence lawyers. These protect the interests of the defendant and challenges evidence provided by the prosecution lawyers. It's the defence lawyers that support and defend the defendant, and the prosecution lawyers who do the opposite. In fact, prosecution lawyers have to prove that 1. An offence was committed, 2. The defendant is guilty, and 3. All evidence was collected following proper procedures. They cannot ask leading questions. In a Crown Court, you'd also find a clerk. They are legally trained and make sure all procedures are being followed. This person helps the lawyers with legal matters and ensures a defendant has a fair trial, even if they do not have legal representation. You also find the witness box. These witnesses have already given either written or verbal statements about the alleged offence and may be called by the prosecution or defence to testify. What this means is that the statement they have given earlier in writing they will give in court as evidence. You'll also find an usher. This person gets the witnesses and swears them in using the oath. They may also pass exhibits, e.g. evidence found on the crime scene, around the courtroom if required. The public gallery is located at the back here. This is the part of the courtroom where the public sit. Anyone is allowed to watch a court case at any time unless the case might be a sensitive one. You do not need to organise a visit in advance. All you need to do is find a court and attend the courtroom that interests you the most. You are welcome to leave whenever you want. You can be any age to go and view a case, but you must be mature enough to be silent. Finally, on the side, you have an area for the press. Members of the media, such as the newspapers, attend the court and make notes in order to report. They are generally not allowed to film or take photographs within the courtroom, so they might draw sketches instead. Please ensure you look at the arrows that show you where each party would be on the plan of the courtroom. This is a magistrates court. The magistrates court do bear many similarities to the Crown Court. For example, there is also an area for the press. There is also a public gallery so that the public can view the case. There is also an usher, as well as a clerk. There is also a stand for the witness, as well as a dock where the defendant will stand. There are also solicitors for prosecution, as well as solicitors for defence. However, there are key differences. Instead of one judge presiding the court, like in a Crown Court, there are 3 magistrates in a magistrates court. They sit on a bench of 3 and hear evidence presented in court. They decide whether the defendant is guilty or not guilty based on this evidence and can give out custodial sentences of a maximum of 6 months in prison or non-custodial sentences of a maximum of £5,000 of a fine. They can refer a case to a Crown Court if they think it is too serious. They are not legally trained and are unpaid volunteers. They must be of good character. They are required to do a minimum of 26 half-day sittings per year, so this is 13 days in total over the year. There is a chair magistrate. The chair magistrate sits in the middle. They are in charge of speaking on behalf of all the magistrates. They must make a fair decision based on other magistrates' decisions too. Another key difference between the Magistrates Court and the Crown Court is that in the Magistrates Court there is no jury. A judge and jury only exist in the Crown Court. As mentioned earlier, in a Crown Court, more serious crimes are tried, whereas in a Magistrates Court, it's the less serious crimes that are tried. It's worth noting that you should know about all these roles in detail. You'll also need to know about how citizens can get involved in the legal system through becoming a magistrate, a juror who serves on jury service, and a witness. Information on all these 3 roles will be provided in another video. What we're going to be looking at now is employment tribunals. How are tribunals different to courts? Like a court, tribunals deal with conflicts and disputes between 2 parties. However, unlike a court, the tribunal will consist of 3 people who preside over the court, who will often be legal professionals, such as a lawyer who chairs the process, and 2 lay people. What we mean by lay people is anyone who performs an official role in court or a tribunal without a background of legal training, who have knowledge or experience of the relevant area. So this could potentially be a trade union representative. If you want to know more about trade unions, please remember to watch the relevant videos in the Rights and Responsibilities folder. The plaintiff, the person making the claim, or respondent, the person receiving the claim, tend to represent themselves or may be represented by a colleague or a trade unionist. It is not expected for a person to have legal representation such as a barrister or solicitor as you would in court, as this is not in keeping with the low cost and accessibility of the tribunal, in comparison to the cost of a court, where the cost is much higher. Tribunals have more independence than courts, and even more independence from laws made by Parliament. If you have a bulk of writing, what you should do is break it down into a number of questions. You can put the questions onto one side of a flashcard and the answer on the other side of the flashcard, and you can play games with them. So you can look at the question and guess the answer, or you can look at the answer and guess the question. You can even play matching activities, where you match the question to the answer. So for example, in order for us to summarise all the information here, I've put it into 7 questions. What do tribunals do? How many people preside over the tribunal? Who presides over the tribunal? What is a plaintiff and respondent? Who may represent the respondent? Why is it not expected for a person to have a lawyer? Give 5 differences between a court and a tribunal. Remember, when you give the 5 differences between the two, make sure you number your bullet points and not just use round circles for your bullet points. It's much easier to remember the facts for your exam if each fact is numbered. So here's 7 questions. Use the bulk of the information to summarise a response for each one, and put it onto flashcards. See if it works for you. Try experimenting with different revision styles. Remember, you should be able to find the response to each and every one of these questions in this bulk of writing. We've come to the end of this video, where we've looked at the difference between Crown Courts, Magistrates Courts and Tribunals. In the next video, you'll be looking at the structure of courts in England and Wales, as well as the role and structure of the Supreme Court.